Welcome to FFRF's Ask an Atheist. I'm Patrick Elliott, Senior Counsel with the Freedom from Religion Foundation. Today we're going to be discussing whether businesses' religious beliefs grant them a license to discriminate against the LGBT community. Recently, the U.S. Supreme Court is taking up the Masterpiece Cake Shop case, which relates to this topic. If you have questions, please submit those below. Please submit those below on Facebook, or you may also email them to askanatheist@ffrf.org. Joining today, I have attorneys Sam Grover and Elizabeth Cavell to talk about the case. And I hope, Liz, hopefully you could just start us off on the basics, what's going on with this Masterpiece Cake Shop.
Okay, so the facts of the case. This started in 2012 in the state of Colorado. A gay couple went into a specific bakery, Masterpiece Cake Shop. They went in to order a wedding cake, and back then, gay marriage was not recognized in Colorado, and so like many couples, they were getting married in the state of Massachusetts, and they were having a wedding reception in their home state in Colorado. Their wedding planner for their reception site referred them to Masterpiece Cake Shop, so they went in to buy their wedding cake. So they walked into the cake shop. They started browsing through photographs of cakes that other customers had bought from Masterpiece. Within a few moments, they were met by the proprietor of Masterpiece, and they were informed within a few moments that he does not make wedding cakes for gay couples, same-sex weddings. So they were denied service within a couple of moments. No other discussion of what they were attempting to order or what they wanted, and so they left. So this all kind of took place within moments. After that, the couple filed a complaint with the Colorado Civil Rights Commission, alleging unlawful discrimination on the basis of their sexual orientation.
And so, that kind of brings up, sometimes people are wondering, how does a case even come about like this? And so, generally, I don't know if Sam, if you could address, just these civil rights laws in general. Many states have these. What's the idea behind them?
Yeah. So the Colorado Anti-Discrimination Act stems out of the same language that you'd find in the federal Civil Rights Act, which is the federal response to the struggle for equal rights for African Americans in the 60s and 70s. The language of both the Colorado state law and the federal law are designed to make it so that places of public accommodation, which includes service industry places as well as hotels and places like that, places of public accommodation, can't discriminate based on protected classes of people. So that's things like race, color, national origin, and then also sex and religion.
Right, and in the state of Colorado, I believe they amended their anti-discrimination law in 2008 to add sexual orientation.
Correct.
And so that's kind of the setup between the facts that happened and the Colorado law, which is not that different from a number of other states have done. So how did we get to the Supreme Court? What is what happened in the lower court case, and ultimately what is the bakery arguing
Right.
now?
So Patrick mentioned we're all attorneys here, and we've been warned not to geek too much and get too technical on this, but what happened after the couple filed a complaint with the Colorado Civil Rights Commission, who enforces the civil rights law in Colorado, was they found that Masterpiece Cake Shop violated the law, and then that was appealed through the Colorado state courts. And so the facts that I sort of just described are not in dispute, but what's being argued to the Supreme Court by the bakery is the same thing that they've argued throughout the Colorado state court procedure, which is a couple of things, but the overarching theme is that being forced to comply with the anti-discrimination laws. In other words, if he's made to comply with these laws and not deny service wedding cakes to gay couples, would violate his First Amendment rights, both in his argument, his free speech rights and his right to free exercise of religion. So number one, he's arguing that making wedding cakes is more than just commercial conduct. It's this artistic expression. In other words, it's speech, it's expressive conduct, and should be protected by the First Amendment. The other thing, number two, he's arguing is that because his reasons for not complying with the law is religious, his sincere religious beliefs, that his free exercise rights are implicated. In other words, the law can't infringe on his right to make this business decision in accordance with his sincere religious beliefs. So.
Right, and so just to get to the posture a little bit, as I understand it, the commission had found the violation, that they did in fact discriminate on the basis of sexual orientation, and declined to find that the First Amendment rights of the baker trumped, were actually infringed here. And then the Colorado Court of Appeals also found discrimination, and then now the Supreme Court has accepted a cert petition from the baker, and basically the state of Colorado and the Civil Rights Commission on one side, as well as the couple represented by the ACLU, are now arguing, before the Supreme Court. And thankfully, Liz, you drafted a brief, an amicus brief on behalf of the Freedom from Religion Foundation and our members, and maybe you could address, some of the arguments that you made.
Right. So we filed a friend of the court brief. Basically, that's a brief that non-parties can file in an important case like this to just sort of address interests that affect their organization or individuals' interests in a case. So what we focused on in our brief was the free exercise argument that's being made in this case, because if the court were to accept that argument, it would amount to a really broad expansion of what is now free exercise rights. So, in other words, we argued that the Supreme Court has never recognized that there's a free exercise right, a First Amendment right, to ignore neutral, generally applicable laws, like the anti-discrimination statute in Colorado. The court has heard arguments like this throughout its history and rejected arguments like this. Most notably, in the civil rights years, they took heard cases that involved arguments that businesses had a free exercise right to ignore or to practice racial discrimination in their business practices. And the Supreme Court and other federal courts have rejected those arguments. So accepting an argument like that now, based on the free exercise clause, would be a massive expansion of what we consider to be religious liberty, and to the detriment of third parties like the couple in this case. The harm, third parties would be harmed in order to vastly expand the religious rights of this small business and business owner.
Right, and I just was going to, play off. You talked about the civil rights cases where the Supreme Court has found, you don't have a religious freedom right to violate these. The more broad context, this is not just are you conservative justice or liberal justice? I think those were very strong opinions. But the other case that comes to mind is Employment Division versus Smith, which is, whether somebody could be denied a public benefit. I think it was maybe even unemployment benefits when they were, for religious reasons, smoking peyote. And I think it was Justice Scalia, strongly said, this is not what the free exercise means. A generally applicable neutral law doesn't mean your religion gets to trump it. And I think your brief is important, or for FFRF to weigh in on it. would be pretty absurd if now everybody, I think this is also from Justice Scalia's, everybody, a religion unto themselves, so a law unto themselves. So if you don't like a law, if you have a religious basis for violating it, that's a get out of jail free. If you have some secular justification, that wouldn't fly. Of course, you then would still be convicted or have to suffer, the monetary consequences for violating it. The other thing I guess I wanted to discuss about this case, because unfortunately I'm on a listserv of law professors who've, said a number of things about this and used hypotheticals, but you had mentioned the facts, but it seems that, at least and maybe Sam can chime in on this too, in some of the cases we've dealt with, religious right law firms are representing the parties. Here it's Alliance Defending Freedom. And as the appeals go on, they start to change the narrative about what actually happened. And so it seems that here, the actual circumstances are being changed a little bit to try to fit in a stronger free speech claim for the plaintiffs. I don't know if either of you have anything to share on that.
So I think it's important to remember, and we all hope that the Supreme Court really takes note of the fact that the facts of what actually happened that amounted to the unlawful discrimination, those facts are undisputed. So, number one, the Masterpiece Cake Shop is a place of public accommodation. It's a retail business that's open to the public. It offers goods and services to the public under Colorado law. It's subject to the law, and its owner doesn't dispute that. The other thing is the encounter between the business owner and the couple who were customers. It's not in dispute what took place in those few moments before they were denied service. They made no inquiries, or they had no discussion about cake design, what their order would be, what the design features would be, what the cake would look like, what it would say, what it would taste like, any other types of images or design features it would have. They were categorically denied the ability to buy a wedding cake from the Masterpiece Cake Shop because they were a same-sex couple. So that's important to remember, and we hope that the Supreme Court doesn't get distracted by any new efforts to sort of highlight the fact that Masterpiece Cake Shop kind of makes a lot of hay out of in its briefing of the fact that they're willing to sell other products to gay couples or gay customers, including, any products for other events, birthday parties and brownies and all the other things you might buy from a bakery that aren't a wedding cake. They're free to buy. And that may or may not be true. That's not something that's an essential fact that amounted to the unlawful conduct in this case.
Right. What else was in the record? I just was going to point out was that 4 or 5 other same-sex couples had been turned away from the bakery. So it wasn't. It's being portrayed to some extent as, I'm going to create this one-of-a-kind sculpture and I can't give it to you. But reality is they've been turning away couples, anything related to a reception, which is what this was, a wedding reception, that they wouldn't do it. So it's a little bit of looking at the circumstances and trying to make a claim where I think the commission's ruling isn't maybe giving its full weight as to what actually happened. Sorry, Sam.
Right.
Oh, I was just going to point out that we shouldn't care about this distinction that Masterpiece Cakes is trying to make between discriminating against a gay couple and discriminating against a practice that only gay couples would engage in, a same-sex wedding. The Supreme Court has already rejected previously that this distinction should mean something. In Lawrence v. Texas, for instance, the 2003 case about anti-sodomy laws, right? Like, conduct that gay people engage in can't be treated specially. Just even though you can't, discriminate against gay people. There's no distinction there.
Right, and it's a fiction. I mean, I appreciated, I believe it was the complainant's brief pointing out that really this would lend itself to, in certain circumstances, if religion was a get-out-of-jail-free card from discrimination laws, then this actual event wouldn't matter. It could be a birthday for somebody who's African American, an anniversary, a gay couple doing an adoption. It could be any number of things. It just so happens to be that the baker thinks that this conduct is inappropriate. It's not. There's nothing special to what happened here, which was that the couple was married at the time. I think this was in 2012. Gay marriage wasn't legal in Colorado. They were married in another state, and then later on had a reception in the state and ordered a cake for it, as anybody would for a celebratory event. So I think that's an important distinction, which is it's trying to be portrayed as somehow the cake is that there's something special about a wedding itself. And the reality is it's because of who they are, not that it was a wedding. They sell wedding cakes. It was because of the sexual orientation of the purchasers.
Right, and exactly. I mean, the facts and what the bakery is seeking to be allowed to do in violation of state law is actually really simple. The issues have gotten really sort of confusing, and I think there are a lot of arguments raised that are both technical and sloppy, and so it's hard to keep track. But essentially, as Colorado pointed out in their brief, this is a bakery that sells that would sell a plain white 3-tiered cake to a heterosexual couple for their wedding, and they will not sell a plain white 3-tiered cake to a gay couple for their wedding. That's pretty plain and simple in terms of what is the reason for the denial of service. It's who the customers are with regard to their sexual orientation, and that is a basis that the state of Colorado has decided business owners cannot make decisions on who to deny service to. So the facts of what happened are pretty simple.
And I guess one thing I wanted to bring up that you discussed in the brief, and I guess connecting this a little bit to the civil rights movement, because there are some insinuation that, oh, this is a cake, that's not as big of a deal. And that was, during the civil rights movement, people were talking about, well, can I, can I eat in a restaurant? Can I stay at a motel? These basic needs. But there were aspects to that go beyond meeting basic needs. And I think you had a quote from Martin Luther King that we had discussed in the brief. I think this is from the letter to the Birmingham jail, where it basically did discuss beyond the mere meeting basic needs, just kind of how society is treating you, being an aspect.
Right, that's right. And just to paraphrase what Martin Luther King Jr. was talking about, it was the when you find your tongue twisted and your speech stammering as you seek to explain to your 6-year-old why she can't go to the public amusement park because she's black. And that's not talking about, gee, can we find access to amusement services? It's talking about the shame and the humiliation of being treated like an inferior person because of who you are. Your immutable characteristics, which the Supreme Court has identified sexual orientation as being an immutable characteristic, just like race. And yes, it's not just, I think Masterpiece Cake Shop is also arguing that, when we're measuring the harm, compared to the violation of his rights, the harm is not that bad for gay people because public opinion has changed so much with regard to support for gay rights and support for marriage equality. And so, because this couple could get a cake anywhere, indeed they did get a cake for free after this controversy, then it's not so important that they not be denied service because of their sexual orientation. And so that sort of addresses, speaks to the idea of, the harm of not being able to get goods and services, although I don't know if everyone in rural Colorado would have the same experience as gay people in the Denver metro area. But putting that aside, it's not just, can these guys get a wedding cake easily? It's, should they be made to feel humiliated and rejected just because of their status as gay people when they're seeking service on the exact same terms and lines of goods as a heterosexual couple? It's humiliating, and it's it's
Yeah, and just to be clear, also, if the Supreme Court accepts Masterpiece Cake's argument and the argument being made by these, religious freedom advocacy organizations, there would be no limiting principle here. There's no way to say, okay, well, this particular religious belief against giving wedding cakes to gay people, like, we're going to protect that, but not protect other religious beliefs that do have to do with serving black people in a, 70s style malt shop. Like, right. you would be rolling back the Civil Rights Act and all the progress we've made since that era.
I think it is intended as a foot in the door. I mean, I don't think the organizations behind the other side think, oh, this is only about this minor issue. That's why I think there's been so much attention, and maybe the public should start paying a little more attention to this case. Certainly the legal community has been paying attention to it and recognizes it could really blow open the door as to either religious discrimination under free speech or religious discrimination under free exercise. It's not limited to cakes for weddings. It's obviously is a much broader issue than that, and so that's why I think there's been so many briefs and so much discussion overall. I think we have, I'll pull out the iPad here for the Ask an Atheist part for some of the questions that we have. Let me just see. Somebody's asking which law, rule, state or federal, how do these, how do these differ? I'm sorry. So the question is about, how do state and federal laws deal with this issue in different ways?
Right. So Sam kind of touched on this in the beginning, just to sort of explain without getting too technical. What's the law that we're even talking about? Why is this a court case? And like Sam said, this isn't anything new. So these civil rights laws have been around for a long time. Colorado's, I think, goes back to the 1880s, and the Federal Civil Rights Act back to the civil rights period, 60s in our country, or at the federal level. So these are laws that regulate businesses, and there's nothing novel about that. Businesses are regulated by the government in tons of different ways. When you open up shop as a business, a big or small, you understand that you're going to be subject to all kinds of laws about all kinds of practices of your business. There's a law that tells you what overtime is and how many hours people can work and what you have to pay them, and food safety if you're in food handling, and workplace safety. So there's nothing novel about laws that regulate businesses. This is one of those laws. Anti-discrimination laws that regulate certain businesses, and different states define it in different ways. Colorado defines a place of public accommodation as any retail business open to the public. So yeah, that's the kinds of laws that we're talking about that are on the books, that are nothing new, and that are nothing really remarkable in terms of how businesses, conduct themselves.
Right. I also was, thinking about this a little bit more, and that it's not even a weird aspect to this is we can have this political debate about what should the law be. The state of Colorado has already decided that. They've said we don't think businesses should provide to turn down customers, places of public accommodation because of somebody's sexual orientation, their race, their national origin. I think they also include marital status and their sex or disability. So this has already been decided by the state, and each state has made that decision. Now we're in a place where is the Supreme Court going to rule, oh no, the federal Constitution doesn't allow greater protections? So you can have the debate of, well, is this a good idea or is this a bad idea? That's something this Colorado legislature has already done. They've decided it's a good idea. Now we have, is there some fundamental basis in the U.S. Constitution that would prohibit them from doing this, or as applied to this circumstance? And so that's kind of the bigger question that I think people are lost on. I think people want to debate, is this smart or is this dumb? And that's the thing that courts are always used to not deciding how wise the law is, but is it foreclosed in some way by the U.S. Constitution? It seems it certainly shouldn't be.
Right. And I think we've gotten a lot of comments on the promo for this this chat, and we just threw up a graphic of some of those comments a couple of minutes ago. And I think kind of along the lines of what Patrick is saying, there's sort of a lot of sort of debate or the idea that what are these laws all about? Like what's either confusion on what these laws are or whether they're on the books, or the policy behind whether these laws are a good idea. In other words, shouldn't private businesses just be able to refuse service to whoever they want for whatever reason they want? No shirt, no shoes, no service is one of the quotes. Right. You know, is that bigoted? And if a business doesn't want to do business with you, don't they have that right? And I mean, like Patrick just pointed out, the answer in Colorado is under some certain limited circumstances, no. And yes, not having a shirt on or not having shoes on is not a protected class of people in Colorado.
Right. It's not an immutable characteristic to not have your shirt on.
Exactly. But the state of Colorado has decided that there are certain narrow reasons on which you cannot refuse to do business with somebody in your private business. One of those is because they're Black or because they're Asian, and another one of those is because they are gay or because of their sexual orientation whatsoever. So yes, private businesses have wide latitude on who they do business with and who they refuse service to and why. And of course, like we said in this case, the baker in this case did not refuse an order. All the parties agree, I think, in this case, that he had every right to refuse to fill a particular order. In other words, I don't do rainbow batter. I don't do, I'm not going to write this message on your cake, or I'm not going to put this image on your cake. What he's not permitted to do is categorically refuse to sell a line of goods to gay people only. That's what we're talking about here. We're not talking about the ability of private businesses to decide who they're going to serve and why. But many states, including the state of Colorado, have decided this is actually one reason that upon which you cannot base your denial of service. And there's nothing really remarkable about that.
Right. I mean, and you just brought to mind, for me, I think one of the comments, there's been a number of comments on the Facebook page about this, but one of the comments was, some businesses have signs that say we may refuse to serve anyone. And so you've already kind of answered that, but maybe an analogy would be a business that's hiring. They obviously can decide on what hiring criteria they want. They may want somebody who can type 80 words per minute, or they may want whatever. They can decide whatever they want. What they can't do by federal law and presumably by state law is discriminate against somebody on the basis of their religion or their race. Here, sexual orientation is also included in that. So businesses can put up signs to say whatever they want. There's no Colorado law that specifies that you must serve people without wearing shirts. Obviously, there is something that says you have to serve customers regardless of their national origin or their race or their religion. So I think maybe that helps distinguish it. As lawyers, maybe we get too wrapped up in, well, of course, this is a protected status, and that's why just coming from either an employment context or like the public accommodations context. You see it in housing in terms of rentals. There's a lot of states and federally protect from discrimination in housing. There are means that a landlord may be able to turn down a client based on their credit score, can't do it based on their religion. So maybe that helps answer. Again, there were maybe half a dozen comments along the same vein that were out there on this, on the same.
Right. And again, there's nothing remarkable about state laws that regulate businesses. You may not agree with the political approach of a certain state to how they regulate businesses. For example, you might think it's crazy what the minimum wage is in California or in New York, but that doesn't mean you're free to not pay your employees the minimum wage. Same thing goes for anti-discrimination laws. You can refuse service on all kinds of bases, but there are laws that regulate the reasons why you can and can't deny or you can and cannot withhold an entire line of goods from people. You can't say, we serve Black customers, but you have to get your food takeout. You can't dine in the restaurant. The Supreme Court has said that a long time ago. You can't hold out different lines of goods and services to people based on their protected status. Colorado's decided sexual orientation is one of those.
Right. Okay. We have a few questions. I don't know how serious these questions are. It seems that this topic, and it's probably can continue to be contentious of people who think the people should be allowed to do this, and maybe not even from a religious perspective. Some of them are. So this person's asking, how does the baker's discrimination against gays differ from discrimination against blacks or Jews? I think to some extent that's the distinction we've been highlighting is an interracial marriage, discrimination against an interracial marriage is exactly the same circumstances that would be here, against a same-sex marriage. So maybe that's, not
Right.
a lot more to share. This person says, the Bible says homosexuals shall be put to death. Is a Christian baker free to ignore laws against homicide? I think this is facetious, obviously, but it's, if you're the Supreme Court, how do you decide the difference between the levels that laws should be given, whether criminal or civil? How do you weigh the get-out-of-jail-free card that would be religion?
Yeah, I think this question highlights an important distinction, an important legal point that these religious liberty organizations are trying to change. And that's the distinction between religious beliefs and action based on one's religious beliefs. The First Amendment right to religious freedom only protects the former. It only protects your right to believe what you want to believe. It does not protect all actions one takes on in furtherance of that religious belief or because, the voices in their head tell them to do so. That you obviously can't murder or sacrifice children just because the Bible endorses that. And that has been a clear line that our government is founded on. And it would be untenable to do what these religious freedom organizations are advocating for, which is to allow people to become a law unto themselves based on their religious beliefs.
All right, we've got a couple more here. Reading this to mean the Federal Civil Rights Act, but the person asks, does the Civil Rights Act include protection for gay people?
Right. So the Federal Civil Rights Act does not include sexual orientation in terms of places of public accommodation and how they can decide to offer goods and services. So in the Federal Civil Rights Act, it includes race, ethnicity, national origin, and religion, I think.
Sex is
And
included,
sex.
yeah.
I don't think sex
Oh,
is included in the Federal Civil Rights Act. If you're aghast, that's a whole nother Ask an Atheist. But most states, with the exception of 5 states, you can probably guess which ones, don't have any state corollary to the Federal Civil Rights Act. So the Federal Civil Rights Act applies in those states, but they don't have their own anti-discrimination laws that expand on those protections any further. Every other state has their own, some that mirror the Federal Civil Rights Act, and some, like the state of Colorado, that go much broader and include other protected characteristics like sexual orientation and marital status and things like that. So the Federal Civil Rights Act is the floor, not the ceiling, and the Constitution has never been found to be any kind of barrier to states that want to broaden those protections.
And we're seeing, even local municipalities differ from their states. Obviously, there have been very big fights about this in North Carolina as to whether a city may adopt something that maybe grant greater protection than what the state allows. And so it's an ongoing debate, and it's not, I just would say it's not abnormal to see from our line of work, we've seen cities oftentimes are the first to adopt greater civil rights protections before it reaches a higher level. So the fact that some states have this, our Congress is not quite there yet. I think it's about time that we include sexual orientation as a protected class alongside these other bases. Those just haven't passed yet. They continue to be introduced. So I think it's something that certainly progress can be had, and it should start at the smaller level and see if that can be implemented there and it protects people, then maybe there's a better argument to adopt it federally.
To that point, actually, FFRF is very proud that we've gotten the city of Madison, where we're headquartered, to adopt an ordinance protecting atheists as a protected class, in addition to religious groups and the other classes.
Right.
So we're hoping to see that sort of expand nationally as well.
I have one long comment here, and I don't know where this is going to go, but Todd Crenshaw wrote, Masterpiece Cake Shop is not about religious beliefs. I bought my wedding cake there 15 years ago. My fiance had a bunch of tattoos. Tattoos are also forbidden. We weren't refused service. If he also refused service to couples on second marriage, couples who ate shellfish, and couples wearing cotton poly blends, he would have an argument. So I think he's just pointing out the hypocrisy here, obviously, with somebody feeling the need to follow what the Bible says. Well, these are all, and some of these are in Leviticus, where apparently homosexuality is also condemned. These are also actions that presumably the baker wouldn't be as inclined to decline service to. Although here, we live in the world where gay marriage has, recently been decided by our courts, and so now we're in this time period where people are, how can they fight back? You have the Kim Davis government officials pushing back, and now here you have some, private businesses, also
Right.
asserting something that they can do to still put their stamp on that they shouldn't be equal citizens in terms of the government protections. Obviously, people can have whatever view they want, but here we're talking about, can the laws of Colorado provide protection? And,
Right.
and that seems that they should.
And I think that comment also goes to Sam's point and the point we tried to make in our brief, which is why it's so untenable to recognize this free exercise right to ignore otherwise neutral laws, because there's just no limiting. Everybody's religion is not only up to which religious dogma they subscribe to. It's up to their own individual interpretation and cherry picking of which religious beliefs are important enough to them to influence their conduct. Right. Here, this comment points out, I don't think the cake shop owner would refuse to bake cakes for second marriages and this and that. Right. And that's right. That just proves the point that it's all up to his own interpretation of what religious beliefs are strong enough to overcome his obligation to follow the law, just like everyone else in business has to.
Right. Well, I think that about does it for questions. Thank you for joining us for FFRF's Ask an Atheist, and please come back next week.